Alright, so I'm a little bit late posting this video. Been kind of out and away, and so I kind of got a little behind. But this is for Monday, March was the 22nd, over the right to privacy. So first, we're going to examine what is this right to privacy. Okay, there's nowhere in the Constitution you can find the right to privacy. Okay, it's not written in there. It's more of an implied right. You know, we talked about implied and express powers of Congress and the president. So you kind of have like implied and express rights, right? Like an express right is freedom of speech. An implied right would be the right of privacy. Okay, it's never stated in there, but it's kind of inferred, especially in the 4th Amendment and the 9th Amendment. I mean, there's really tons of cases you can make, but those are some of the best. And when this right of privacy came to fruition was in a 1965 case known as Griswold versus Connecticut. The Planned Parenthood Association in Connecticut was challenging a law that was on the books. It wasn't really enforced, but they were just challenging the notion, and they were really setting the wheels in motion for a larger image to kind of get this idea of the right to privacy. But they're challenging a law that made it illegal for couples to use contraceptives. The law was overturned by the court, and because the court said that even though the Constitution doesn't directly state there's a right to privacy, it basically provided what they call a penumbra of privacy, which basically means like an umbrella privacy, when an individual's privacy is protected from government intrusion. Okay, so they basically said there's this big government, or there's this big, umbrella privacy expressed in different parts of the Constitution. And so even though it doesn't directly say it, we have this right of privacy, and that includes couples' rights to use contraceptives if they wanted to. And so this big debate, it really took fruition in Robert Bork's Supreme Court confirmation hearing. Robert Bork was appointed by Reagan. Of course, he was shot down by the Democrats in the Senate. And it's really funny, well, not funny, but you have Joe Biden, obviously he's running for president now, who was one of the chairs of the Senate Judiciary Committee, and they have this really interesting about 3-minute discussion about the right to privacy. Robert Bork basically is making the notions that we have to be careful about just writing in rights like the right to privacy, because what can that lead to? What does that mean? Where Joe Biden is saying, look, we need to have the right to privacy because otherwise the government, could have like wiretaps, and they could be listening in, and they find out that people are using, contraceptives. They could, invade the bedroom and also arrest couples, and that'd be a great, travesty. And, Robert Bork said it's, laughable that any judge would, give a warrant to, invade someone's bedroom, but it's kind of a good debate on the issue of the right to privacy. All right, so Roe versus Wade. In AP government, this is one of our foundational cases, and I'm gonna be honest, okay? Everyone's got an opinion about Roe versus Wade, all right? And I'm no different than anyone else, but I'm gonna try to just focus on the legal aspect of this. So when you're listening to this, I understand there are people who think it's a great decision. There are people who think it's a terrible decision. Everyone's got their opinion, but I'm going to really focus just on what did the court say and why is that important to our class. So the whole case, lady named Norma McCorvey, she's a woman in Texas, and she was seeking an abortion. And in Texas at that time, you can only get an abortion if you are a victim of rape or incest. She was neither, so she was trying to sue to state that, this umbrella of a right to privacy extends to her ability to choose whether or not she wants to go to term with her pregnancy. So she brought it to court. Roe, that was her side, was arguing that abortion is, a vital health care decision and falls under this, right to privacy. There's really no other medical procedure. They're arguing that the government can come in and say, well, no, you can't have this procedure. Only in certain instances can you have this procedure. So that was their argument. Wade, which was Texas, their argument is basically the state had two compelling interests to prohibit abortions. The first one was to protect the health of the mother, and the second one was to protect the life of the fetus. So it was a 7-2 decision. It's a very strange decision because it was not a Republican versus Democrat decision. There were several Republicans, in fact, I don't want to call them Republicans, Republican appointees in the decision, including Harry Blackmun, who is the justice that writes the decision. He was a Nixon appointee. And then one of the two dissenting opinions was a Kennedy appointee, with Democrat appointees. So it's not, it's an interesting decision in that it was not, Republican versus Democrat appointees. And Harry Blackmun comes up with this very confusing trimester schedule. Okay, so trimester, you're talking about 3 months. So the first 3 months of a pregnancy, abortion is considered relatively safe, according to Harry Blackmun, who I guess is also a doctor. It basically says states could really not infringe upon a woman's right to have an abortion. And then in the second trimester, he said states could have some interest because around the 20-week period, the 5-month period, a fetus can reach viability. And then you can start to make all sorts of arguments about the heart, fetal heartbeat. Talk about when the fetus can feel pain and all that sorts of stuff. So you could start to argue that the states have some compelling interest. And then in the third trimester, it said that states really have a full compelling interest, right? Because you have gone past the term of viability. Obviously, the later an abortion occurs, the more health factors you have to consider. And so basically, it's this graduated trimester schedule that basically the further along you get in a trimester or in the woman's pregnancy, the more restrictions a state could put on it. But it also basically gave the larger citation that basically the 14th Amendment's concept of personal liberty, basically whether it is a right to choose whether or not you're going to go to term with your pregnancy. So basically the 14th Amendment is where they found it. So it's kind of confusing because you're like, wait, is this in the 4th Amendment, the 9th Amendment, the 14th Amendment? Where is this right to privacy that encompasses obviously a very controversial decision in abortion? Where is this found? The dissenting opinion, right? There was William Rehnquist, a Nixon appointee, and Byron White, a Kennedy appointee. Basically, the first thing is the court says, the 14th Amendment has a right, which apparently was unknown to the drafters of the amendment. They're basically saying, so apparently the people who wrote the 14th Amendment, they didn't even know that they were creating an amendment that would be later used to justify a woman's right to choose whether or not she's having an abortion. So they said that's, not the purpose of the 14th Amendment. They also say there's nothing in the history of the language of the Constitution to support the court's judgment. Meaning, there's nothing in the Constitution that you can claim supports this right to an abortion. And so the decision obviously did not solve the issue because it is still obviously one of the more hotly contested decisions by the Supreme Court. Now, basically, that's one of the first things someone wants to know when someone gets appointed to the court is, what's your stance on Roe versus Wade? And that was a big thing with Justice Kavanaugh, who was just appointed, Susan Collins, who was one of the moderate swing votes on the Senate from Maine, a Republican. She felt that Kavanaugh wasn't going to go out and try to overturn Roe, and so that's why she voted for him. So the challenges since Roe versus Wade, so 60 million abortions have occurred in the United States since then. Kind of an interesting fact story. Norma McCorvey, the lady who sought an abortion that started this whole case, she did a complete 180. Later on in her life, she regretted her decision. She became, a big key part of the pro-life movement. And so a lot of people kind of look at that as, an interesting factoid of this story. There's been lots of cases that have kind of chipped away at Roe. There's kind of two ideas about you're going to overturn Roe versus Wade. How would it happen? You could chip away at it piece by piece by piece, or you could go at it, and just try to overturn it in one fellow case. And that's what this case right here in 1992, Planned Parenthood versus Casey did. It was attempting basically to overturn Roe versus Wade. And they modified Roe versus Wade. It was a 5-4 decision this time. Anthony Kennedy, the longtime swing vote of the Supreme Court. This is kind of the first big case he is a swing vote on, because there's a lot of stories that, at the last second, he swung his vote from one side of the aisle to the other. And basically the court kind of said, look, okay, the trimester framework is not really a legal framework. So the new legal framework that you have to consider when debating abortion, or determining if an abortion procedure is constitutional, is, does the regulation put an undue burden on an individual? And what an undue burden is, it basically a substantial obstacle in the path of a woman seeking an abortion before the fetus obtains viability. So, what does that mean? That basically means you kind of think about things like making a woman have an ultrasound before an abortion. Is that an undue burden, from her, getting her right to an abortion? In Louisiana, they passed a law that's currently being challenged, that a doctor who performs an abortion has to have admitting privileges within 30 miles of where the abortion is taking place. And so people have said that is an undue burden. But basically, that's the new test when looking at abortion procedures. Is not really this trimester test. Is now, does the regulation put an undue burden on the woman who wants to obtain an abortion before it obtains viability? All right, so it's a very confusing, it's a very messy case for such a controversial issue. There are a lot of people who are on the pro-choice side who are very upset with the Roe versus Wade decision, including Justice Ruth Bader Ginsburg. She said it was too much, too quickly, and now what's happened, instead of building on that right, Ruth Bader Ginsburg has said they're now chipping away at that right. She stated if it would have been more of a narrow decision instead of this big and large encompassing decision, it might have changed the course for women's reproductive rights. All right, so that is our case. That's our privacy cases. On Tuesday, you'll be looking at some of our other 14th Amendment cases, physician-assisted suicide, same-sex cases, and then our civil rights cases as well.